Hi everyone, Attorney Rachel Gretzner here with another Family Law Friday. This week I'm answering the topic of when do we get to separate our finances when we're getting divorced? So the answer to this question, I'm sure you're sick of hearing this by now if you've listened to a lot of my videos, is it depends. And the reason for that is because when you're getting divorced, separating out your daily finances and going from having your marital money together versus living separately or managing your money separately is a lot of times more of a practical issue than it is a legal issue. However, I will say that courts typically like to see what we call status quo. What that means is during the period of the divorce, before the divorce is final, while everything is getting resolved, negotiated, potentially litigated, whatever is happening to get your case to resolution, the courts like to see that the finances remain the same as they were before you were getting divorced. And frequently, courts will order status quo on what we call an ex parte basis. So that means that the court might make that order without the other party's input whatsoever. And that the reason for that is because courts want to just ensure, first, they just want to make sure that everyone has access to money during a divorce. Status quo can be complicated. It's not necessarily the best or the right solution in every case. For example, status quo can get complicated if you and your spouse are no longer living together at the time of your separation. It can get complicated if you and your spouse have a particularly high debt load. It can be the wrong thing for you if you and your spouse have extremely unequal incomes. It could be the wrong thing for you if you and your spouse haven't made any agreement or had any discussion about how bills should be paid prior to the time of the filing of the divorce. In particular, it can be complicated and potentially not the right outcome if one person is preventing the other person from having access to money. It can be complicated if one person is, kind of holding all the information about the money and the other person knows really very little or has very little access to that information because maybe the bank accounts are all held in the wife's name and so the husband doesn't really know what's going on, or vice versa. One issue that I see frequently that does come up is that, if you and your spouse work together in a family business, then again, status quo can be really challenging and problematic. And some people don't want to work together in the family business while they're going through a divorce. Some people are happy to keep doing that. So it really just depends. If you are considering a divorce and one of those more complicating issues applies to you, then you really want to make sure that you are working with an attorney from the very beginning before you even file for divorce to make sure that you aren't losing your access to funds during your divorce, and also so that you don't unfairly withhold access to funds from your spouse, because the reality is divorce is about equity, right, which is the legal term for fairness. And so it's really important that as you're going through that process of divorce, that you're really thinking about equity and fairness and what makes sense for you, because that is the law that underpins the practical decisions that you and your spouse need to make as you decide how to separate. So if you're considering divorce, and in particular, if you need help figuring out what makes sense for how to split your finances on a temporary basis until your divorce is final, give our office a call. We're here to help.